So let's take a look at the third of four chapters, third of three chapters rather, in Module 4. So we're going to look at product warranties, which I almost touched on a minute ago. So let me just extend that one step further. So we just talked about inspection. Inspection is not an element of warranty. Inspection says, I ordered 60 live lobsters. I looked in the box. I had 55 live lobsters, 5 dead ones. So indeed, there were 60 lobsters, but only 55 were usable. So that's inspection. Warranty is a little bit different, and warranty is generally not going to deal with lobsters, although you might have a warranty issue. Let's think about lobsters and a warranty issue. Suppose that you were supposed to get 60 1-pound or larger lobsters. The bigger the lobster, the more they sell for. 2-pound lobster sells for sells for well more than twice the cost of a 1-pound lobster because they're easier to get a whole bunch of meat out of. So people like to, if they can get their hands on a big lobster, that's really cool. So obviously I'm a big fan of lobster growing up in the Northeast. So, but in any event, what happens is that the warranty might be the weight and size of the lobster. So the inspection says, oh, we got 55 live lobsters. A week later, they hear from the restaurants, and the restaurants say, hey, you were supposed to deliver to us at least 10 1-pound lobsters, and we got 3 or 4 of them were only 3/4 of a pound. We're unhappy because we didn't get the weight of the lobsters that we had ordered on our invoice. So their dispute is as a local customer is between the seafood wholesaler here in Houston and that company. But if you think about it, that's going to cause a ripple back to the company in Boston to say, you didn't sell us the weight of the lobsters that you wanted. So again, there's a little bit of difference between the warranty, what was warranted, and the inspection. Now, going back to the example that I used, the real life example of these big pumps, is the seller, of course, wants their warranty to run for 1 year from the day that it leaves their loading dock. The buyer, on the other hand, again, they may be waiting 3 to 6 months to put that big pump into daily use in the new water plant or sewer plant, wants the warranty to start with the first day it's installed. So one of the issues that I see the seller, the pump manufacturer, and the buyer, usually the general contractor building the new water or sewer plant, is how do we work out this warranty issue? And the warranty issue could include things like the pump is supposed to move 50,000 gallons of water a day. Again, these are very large pumps for massive commercial operations, usually in big cities. And so it's supposed to move 50,000 gallons a day. And after it's installed in the factory or the plant, it's only moving 40,000 gallons a day. And the question is, does that mean that the pump is under capacity, has a defect, and so forth? And so that would get into the issue of warranty versus the issue of inspection. One of the saddest things in the world is the issue of bed bugs. They are a very difficult problem to deal with. I don't know if anybody on the call tonight has dealt with it, but it's pretty nasty. Fortunately, they've come up with some new solutions for issues with bed bugs. New York City had a big problem with bed bugs, I guess 5 or 6 years ago. And this one, Catskills, of course, are in upstate New York. It's Catskills Mountains. And so she sued for $20 million, saying she suffered 500 bed bug bites while staying there. I don't quite understand that, because I'll tell you, if I was at a hotel for the night and I got bit even once or twice, I think I'd get my butt out of bed and check into another hotel in a big hurry. And by the way, if that happens to you, unfortunately, you're going to need to leave all your luggage there, because anything that you have that may have been exposed to the bed bugs. They're quite aggressive little critters. May very well go with you now that you've exposed your luggage to your next stop. So it's a very difficult problem to deal with. But certainly, I don't think somebody's going to get $20 million under the circumstances. Now, we're going to get through a fair amount of terminology in this chapter 23. So, but we want you to keep relating things back, building carefully. And I'm addressing the issue of the quizzes and just the amount of material included in the course is a lot of the terms that you've already learned are repeated. So, for instance, we talked about an express contract, express warranty. A warranty is a special form of a contract. Well, what does express means? It means you said it. It wasn't a mystery. It wasn't implied. You said to somebody purchasing an automobile, this automobile gets great gas mileage. It's going to get 20 miles a gallon. That is a express warranty that car will get 20 miles a gallon under normal driving conditions. And so the words warranty or guarantee are not required. Now, if the person gives you some other type of wording, this is where it gets dicey. So, for instance, suppose I say to you, this car is really a great sporty, classy car, and it gets good gas mileage. So you buy the car and you take it out, and it gets 14 miles a gallon, so you're pretty unhappy, and you come back to the seller and you say, but you told me the car was going to get a good gas mileage. Well, since it's not a specific warranty, it comes off as an opinion, and the opinion is not going to be actionable. Now, one of the things that's rather obvious is you shouldn't be able to sell something if you don't own it. And the subject here is the warranty of title. So the seller warrants conveyance of good title to the buyer and has rights to sell that item. So this is something that cannot be waived by the seller. So if I sell you something, I am representing to you that I own that item, or if not own it, I have the right to sell it, and that you're not going to be challenged by someone else saying, whoa, wait a minute, you may have thought you bought it from him, but he didn't have title, so he didn't have a right to sell it. An example of that includes something like, for instance, where you go to a place like the Bluebird resale shop and you buy something that's on consignment. The consignment shop is representing to you that they can obtain the title from the actual owner and that they have the authority to sell it. Folks, I've got some background noise there. Please, if you are, please make sure your mics are muted. Thank you. Should be on my screen. It's my lower left-hand corner. It may be in a different place on your computers. Thank you. Now, one of the more interesting things on our chapter on warranties here is the implied warranty of merchantability. Now, this is a very special warranty, and this comes with all sales of goods, that it's supposed to do what it is. And so if you buy a toaster, the implied warranty merchantability says the toaster will toast. It's not complicated. This is not intended to be a complex situation. It better make toast. Now, if it doesn't make toast, then you can say it's a breach of warranty. And so what happens is that if a merchant doesn't want to give you a warranty, then instead of it being an implied warranty, they have to do a visible waiver of warranty. Now, I challenge you tonight, don't do it while we're on class time here, to go and look in your any item you've purchased recently. You bought a cell phone, you bought a laptop, you bought a toaster. Most of those items are going to have a little instruction manual in the box with the item. And one of the things that's going to be in there is the warranty. It may have, hey, this is what's in the box. Here's the instructions for using it, maybe in a couple languages. And then it goes on to say, here is your limited warranty. That limited warranty in 99.9% of the cases is going to say, we are waiving the implied warranty of merchantability and replacing it with our warranty, which only provides for 90 days of coverage if you're buying a low-cost consumer appliance, up to, say, 2 years if you're buying a nicer appliance or higher-end product. So this implied warranty merchantability applies to all sales of goods unless the seller disclaims the implied warranty merchantability, and in most cases, your sellers will do that here in the United States. Now, contrast that with yet another implied warranty. This is the implied warranty of fitness for a particular purpose. And what's interesting about this is that it's not the same. And I think for some students, it may be difficult to contrast the one we just looked at with this one. But let me give you an example. At the university, I'm usually teaching near the Central Green. We have people that cut the grass. So the maintenance people for the university go to a lawnmower specialty shop and say, hey, we've got this tract of grass, we've got this, that, and the other thing. We need a lawnmower that fits our purposes. And so what happens is that the lawnmower dealer says, oh, I've got the perfect lawnmower. It's, John Deere XXX or whatever. And that means that that dealership has specifically warranted that that lawnmower will serve the purpose that the university representative told to the dealer. And so this is a very important concept. And so, again, the item might not be defective. They bring this big lawnmower back to the university. They use it for a while, and it's not getting the job done. Well, that's warranty of fitness for a particular purpose, because even though it's not defective, it doesn't do what it's supposed to do given the circumstances. So as with the implied warranty of habitability, of merchantability rather, the implied warranty of fitness for a particular purpose does require disclaimer if you're not going to honor it. And not surprisingly, most warranties that for items that you purchase today are going to disclaim the implied warranty of merchantability, and they're going to disclaim the implied warranty of fitness for a particular purpose. So you check that out on things you've purchased recently with the little booklets there. So it needs to be an express disclaimer of warranties. You can't just hope it's not going to be seen. So for the implied warranty of merchantability, you must use the word merchantability, and I think you'll find that that's pretty consistent out there. And it must be conspicuous. So when you look through your little warranty section of your owner's manual, it's going to say, we disclaim the implied warranty of merchantability, and we disclaim the implied warranty of fitness for a particular purpose. Now, the slide tells you it could be an oral agreement. Lots of luck on enforcing that at the courthouse. Virtually no manufacturer is going to rely on an oral agreement. Might occur through the course of performance. Again, I don't think that disclaimer is going to work. So again, you're going to see this in writing virtually 100% of the time. And then the Magnuson-Moss Warranty Act is also what's known as the Lemon Law. And what happened is in the mid-70s, U.S. Auto manufacturers were trying to make the cars more pollution sensitive or more pollution efficient. And so what happened is that they began experimenting with different pollution controls. Long story short, the Fords and Chevys, 73, 74, 75, were some of the worst American cars ever made. So after these cars had failed a great deal, and there were a whole lot of people upset, they went to Congress and said, you know what? Because vehicles are a huge purchase, the largest purchase other than your home, and because of the various factors that come in, we're really hurting. And we need manufacturers to be responsible for if they make bad cars, because they're such a large investment. They have a big impact on the American family. So Magnus and Moss says, if a car is a lemon, as the law is referred to, the lemon law, then it is likely that it'll be repaired more than once. So if the car has multiple repairs for the same problem, then Magnus and Moss will let you bring the car back. And I've actually been an arbitrator in some Magnus and Moss or lemon law hearings where we actually ordered Chevrolet to buy back a Chevrolet Corvette, not Camaro, Corvette, $50,000 Corvette. Told General Motors take the car back, and they did. Now, you need to watch out for this term "as is." I'm presently driving a used car, and I was driving a used car before that. Both of those cars I purchased had some problems, but it was my responsibility because I bought the car as is. So even if it's a merchant, if they say to you, hey, it's a used car, we're making you the best deal you can get, but you drive it off the lot, that's your problem. That is an as-is sale. Now, it cannot be used to disclaim fraud. And here's an example of fraud. I don't think this happens very often today, but people used to do a lot more work on their cars and were more familiar with their cars. But one of the things that would happen is with automatic transmissions, the automatic transmission would start going out on the car. And obviously, if you go test drive a car and the automatic transmission doesn't shift smoothly, you're kind of stuck with the car. It's going to be very hard to sell the car. So what people would do is they would actually put sawdust in the transmission fluid to cover up the failure of the transmission. Now, that'll only last a short period of time before it totally gums up the transmission and probably ensures that the transmission will fail. But in any event, these yahoos went and added sawdust to the transmission to make it run smoother, and then it would fail sometime afterwards, but it would be beyond the as-is or 7-day approval period or something like that. So what can we do about this? Well, if you're the seller, one of the things you want to do is limit the remedies available for breach of warranty. And this addresses this inspection issue that we raised a few minutes ago, which is you want to make sure that people come forward within a reasonable period of time and say, hey, this didn't work. So most new cars come with a 1-year warranty. You may think it's longer than that, but a lot of companies will have a 1-year warranty for everything, and then a 3 to 5 year warranty for the drivetrain of the vehicle, the critical parts of getting the vehicle to start and run. And so some of the remedies include limiting consequential damages. And so what they'll say is, yeah, you were on a big trip and your car failed, tough luck. We're going to warranty the car. We're going to put a new transmission in the car, but it's not our problem that you had to have it towed, 200 miles back to Houston and ruined your family vacation. That's your problem, sucker. But that's the way this kind of works. So most of the corporations out there do limit damages. Nicole, Letitia, some of you folks, please be sure to mute your microphones, okay? Unless you're asking a question, obviously. Now, sometimes there are limits on whether you limit a warranty or the length of time you give people before you limit the warranty. And the benchmark on that is the topic of unconscionability. And remember, we talked about this difficult word in a couple different settings. So if there's a good example of this in the Bluebell case, many of you are familiar with the fact that Bluebell had to stop selling ice cream for a while because they sold some ice cream with listeria in it, a very serious contaminant, and the listeria killed 3 people, and that was before many years before COVID-19 and all this. So an effort to limit the representation of the safety of food would probably be found unconscionable. When you sell food, it needs to be safe for a reasonable period of time. Now, notice, remember we talked about the issue with the dispute between the lobster wholesaler and the seafood wholesaler. Well, this is all about notice. You must give people notice within a reasonable period of time that there's been a breach of the warranty. So if you've got a car and it breaks down and it's still under the factory warranty, of course, generally speaking, you want your car to be operating, but you're going to need to give notice fairly quickly. So one of the things that we wanted to ask about was third parties. Now, when this whole issue of warranty got started, over 100 years ago, it used to be argued this way. Well, you bought this lawnmower from the lawnmower company, and then you resold it to your neighbor. Well, you may have had a warranty, but your neighbor has no warranty because your neighbor bought it from you and not from an authorized dealer. So it used to be that you had to have had a direct relationship, also known as privity. Privity is just a specialized word that means that you're in a contractual relationship. But a lot of that has changed today, where if somebody owns the item and is still relatively new, that they're going to be able to make a claim against the manufacturer, even if that's not the way things were intended with this horizontal and vertical privity. So again, most of the time today, strict privity is not required. So there's a couple different ways to look at this. Warranty extends to any person in the family. The warranty extends to any person reasonably anticipated to use the item. The warranty extends to any person injured by the good. Now, I don't like this in this particular chapter because this is going to be a tort claim. Remember, we talked about torts on the first night of class. And so, again, tort is a civil wrong where you file a suit against somebody. So if you're hurt because a car's defective, technically you're not bringing a warranty claim, you're bringing a tort claim saying you made a bad item, you were negligent, and your negligence caused me to get hurt by virtue of the vehicle that you manufactured. So you could view it as a breach of warranty, but it doesn't really function the same way over at the courthouse. Now, as we mentioned, this is another slide to flag some very useful information here in a usable format where you can really take a good look at it. Again, one of my suggestions is when you hit these specific slides, you may want to collect them into kind of an exam summary area so that you have better information or more condensed information to review, since there is a lot of material in this class. So the conditions of goods giving rise to liability. So warranty and merchantability does not fit for ordinary purpose. Strict tort liability in the restatement, defective, and it's unreasonably dangerous. And then note your comparison here between merchantability, warranty, and then strict tort liability. You need to give notice within a reasonable period of time. In strict liability, you're not required to give notice within a reasonable period of time. But again, I generally speaking, I would file suit as soon as I can. So some of the other things, again, this is slide 3 of 3. Again, these are very useful slides to summarize a lot of information in a concise format. Is the protected persons under the warranty and merchantability, is the third persons. Strict tort liability focuses on the consumer. Protected injuries to person or his or her property. Physical harm to the ultimate user. So this again is contrasting the, the nature of warranty under the merchantability versus tort liability, which again we covered earlier in the course. So we just want you to see the difference from the two. So statute of limitations, warranty is 4 years from tender of delivery. Again, this is going to be disclaimed, so usually this is not going to be there. And then state law varies from 1 to 3 years for an injury. Here in Texas, 2 years is the standard for most torts, not all. So again, the contract for international sale of goods, compact for international sale of goods, CISG, is not exactly the same as Uniform Commercial Code, but interestingly, its warranty provisions are pretty similar to the Uniform Commercial Code provisions. So CISG captures the essence of the warranty merchantability and the warranty of fitness for a particular purpose under the code.